Hello all, this is a criminal procedure topic and it's linked to Chapter 1, Part B of the Miller and Wright text. Now at the level of constitutional doctrine, what we're talking about is this tiny little doctrine called Ferretta versus California, a 1975 case. In this case, the U.S. Supreme Court said that just as there is a right to counsel, the flip side of that coin, there is also a right to refuse counsel, and the court grounded this in notions of individual autonomy. The reason I call this a tiny constitutional doctrine is because it does not produce that many defendants who actually represent themselves in a trial. On the other hand, this tiny little doctrine is worth studying because working back behind it are these two huge forces in legal practice in the criminal courts. The first of those is waiver of counsel, not at trial, but pre-trial. Actually, a good number of defendants waive counsel pre-trial, and so Ferretta is our window into that hard-to-see world. The second major legal practice going on here is selection of counsel. A lot of the Ferretta cases are actually examples of defendants who just aren't getting along with their attorney, would like to find somebody else. It's often a fractious relationship, and so we see some of that at work in these Ferretta cases. So with that background, let's jump in. Let's start with a case study in the exercise of Ferretta rights. State v. Spencer. Spencer was arrested for growing marijuana. He wants to fight the charges. He's got a retained lawyer, Mock. Mock is willing to go forward with the case on Spencer's terms. He's going to fight it, doesn't want to plead it. But then he files a suppression motion and loses it. The government's evidence of the drugs found on Spencer's property is going to come in. And so at that point, Mock thinks that the best thing to do is cut a plea deal, but Spencer doesn't agree. He still wants to fight it at trial. So Mock moves to withdraw. Days before the scheduled trial, the court says, okay, you can withdraw because you and your client are disagreeing over this fundamental question. And then the court appoints a new lawyer, even though Spencer's saying, no, I don't want this new lawyer. I want to represent myself and go to trial. But the court insists, no, you're going to take McCoy. The trial is continued until a year later. McCoy represents him at trial. As the court says, Attorney McCoy fully represented defendant prior to and during the trial, but it didn't go well. The jury comes back with a verdict of guilty. Now, under the federal Constitution, when a defendant says, I don't want that defense counsel at trial, I want to represent myself, and then you've got two options under federal law. First, under Ferretta, you can just have the defendant represent himself and you're on your own. You give him proper warnings. You say, do you understand what the risks are involved in this? But as long as you explain fully what's going on, then Ferretta says, one option is just to let the defendant go forward alone. Another option, a second option under federal law, is called standby counsel, where you say, all right, defendant, you're representing yourself, but I'm going to appoint a lawyer who will be sitting behind you. And if at any moment you want to give this up and hand it over to the standby counsel, they'll prep the case, they'll be ready, they will be there to answer legal questions for you, but they will not represent you in the way that defense counsel normally does. They are not active in the case, they are only there on standby. So either pure self-representation or standby counsel are available under federal law once a defendant says, I want to represent myself. The mystery here is that the trial judge didn't do either of those. Didn't let Spencer go forward alone, didn't represent or didn't appoint McCoy as standby counsel. McCoy fully represented Spencer at the trial. So here's a mystery. How can the trial judge do that? And even more interestingly, how can the Iowa Supreme Court affirm this conviction when it plainly wasn't a Ferretta self-representation and it plainly wasn't standby counsel? Now, one possibility is that Spencer really didn't waive. Sometimes you see in these cases where a defendant makes some noises about waiving counsel, but then when you press on it a little bit, they're a little bit more equivocal, and so the judge goes ahead and leaves a defense lawyer in the case. But it's hard to say that's going on in this case. You read the transcript in both opinions, and we've got here the defendant saying things like, I feel like, well, you see the quotes here, and I'm about to mark it in red, I hope. I feel like I would be better off, there it is, I would be better off defending myself, Your Honor. He, that is the lawyer, doesn't want to listen to what I'm telling him. And again, I don't see how you can force me to pay the attorney's fees for this appointed counsel. I think I'll do just as good a job myself. And at the end, the judge, in usual perfunctory fashion, says, does that meet with your approval? And the defendant, not disrespectful, but certainly not cooperating, says, no, it doesn't meet with my approval, Your Honor. If you're going to force it on me, I'm going to have to take it. So it's pretty plain that he is very clearly making a voluntary waiver, and we know from other parts of the case that it's a knowing waiver. The judge described very carefully what the consequences would be, and he knew what he was doing, but said, no, let me take this on myself. Now, another possible answer to this mystery is timing. Very often in these cases, the defendant will ask to represent himself or herself, but the judge will say, no, trial's tomorrow, too late, I'm just not going to let you back out because all of our plans have been built around a lawyer being in the case. But again, that wasn't going on here because we had a year in between the appointment of McCoy as the second lawyer and the date of the trial. If the judge was willing to postpone for a year for new counsel, he could have postponed for self-representation. So the timing of the request doesn't seem to be explaining the mystery here. Now, before we solve the mystery of Spencer, let's move on to case study number 2. You didn't read about this one, but it's State versus Muhammad, which was a famous case from Virginia in 2003. You may remember the D.C. sniper crimes, horrific murders. John Allen Muhammad, who's pictured here, went on a shooting spree and just every so often would park his van, would line up his long-range rifle and shoot people at random as they were going about doing their ordinary business of life. He chose his victims more or less at random. At the time of his trial, he had assigned counsel, highly competent counsel, but he was insisting on representing himself, and at first the judge let him begin to do that because he felt he didn't have much choice. If he ruled otherwise, there might be a Ferretta claim later on. Now, Muhammad comes into the trial early in the proceedings, and he has a toothache. He has an abscess in his tooth, and he says, I'm not going to be able to go forward today as my own counsel because I'm feeling so badly. Can I bring the lawyers in for today? And the judge sees an opening and says, well, I think it's a great idea to bring the lawyers in. Now, I've seen you operate in the courtroom, and you're making some points. You're not bad, but you're not nearly as good as these lawyers could be for you. And I think it's a good idea to put them in. But once I put them in, I'm not going to take them back out. So I'm going to give you a recess. You go out and you talk to these lawyers and you decide whether you want to let them in for good. So Muhammad goes out and thinks for a while, and then he comes back in and he says, are you going to switch back again? He says, yes, Your Honor. I'm ready to switch back and let these lawyers represent me during the trial. And then the judge, just to make a clean record, says, now, just to be clear, is this because of your tooth, or is this because you think they'll do a good job for you? He says the latter. I think it's just that they're going to do a good job representing me. You can feel everybody in the courtroom breathing a sigh of relief. Certainly the judge. I mean, Millett was looking for his chance to bring lawyers back into this high-visibility murder case. Even Conway, the DA, he's not especially thrilled going into this case with no defense lawyer on the other side. So we've got everybody sort of, plenty happy that now we've got lawyers back in the case. So here's my resolution of the mystery of the missing Ferretta rights in both of these cases. Really, at the end of the day, Ferretta has no natural constituency in the professional criminal courtroom. There's nobody there who's really thrilled about the defendant exercising self-representation rights. If you think about the different actors, defense lawyers just see a train wreck happening. They're kind of closing their eyes and watching a disaster unfold as the defendant loses advantages here and there. The judge would much rather have a represented defendant. It'll just speed things up. It'll make business go as usual. Technically, the same review standards will apply, the same legal standards will apply at trial, and the same review standards on appeal. That being said, everybody really is going to bend over backwards to make things work for this defendant, and the judge would just rather not have to go through that exercise. Even the prosecutor. I mean, there are some prosecutors who'd say, hey, great, nobody on the other side, let me steamroll them, ready to go. But I think there are a substantial number of prosecutors who would say, just for security of conviction, I'm going to win this case, and when I win it, I want as few grounds for appeal as possible. And I just want the business to go in a professional way. I want the business to be processed the way we're used to it, and that happens best when there's a professional on the other side. So not all prosecutors, but I think a lot of prosecutors would rather just not deal with Ferretta rights. So given this lack of a natural constituency for Ferretta, what happens is at the trial court level, the trial judge is looking for reasons to deny a motion for self-representation. It could be, you're too late, the trial's about to happen. Or it could be, you said something equivocal, and I think that means you really don't want to waive your right to counsel. So I don't think you've made a clear, knowing waiver. It could also be that the judge says, all right, I hear you want to represent yourself, but I'm going to appoint standby counsel, and then at the first opening, when you express some ambiguity about this or some reservations, that's when I'm going to ask counsel to jump in. So at the trial level, you're going to have the judge looking for reasons to bring in the lawyer. Now, this doesn't happen all the time. This is just a very common setting. And on appeal, the appellate judges are quite deferential to trial court reasons for denying these Ferretta motions. They'll say, yeah, there wasn't enough time, or yeah, it was equivocal, as we saw in Spencer, or yeah, standby counsel performed an appropriate role here. So at the end of the day, these things, these cases are relatively rare where a defendant actually represents himself or herself at trial. There's an old saying that a defendant who self-represents has a fool for a client. Is that true? Well, in movie terms, maybe so. I have here Woody Allen, who is pictured here in his famous movie Bananas. And I mention it here because there's a great self-interrogation scene where he sits in the witness chair, the witness seat, and testifies, and then hops up and asks questions as the lawyer, and then runs back around and sits in the chair again. And it's a frantic, wonderful mess. And he's sort of playing out the idea that that if you represent yourself, then you have a fool for a client. But is it really true? There's a little bit of evidence to suggest that maybe this statement is not true in criminal courts. At least maybe not. One bit of evidence comes from the scholar Erika Hashimoto, who studied the records in federal cases and tracked what the sentence was, both in cases where the defendant was represented and cases where the defendant was not. and found that the outcomes were actually a little better for self-represented defendants than for others. Now, that could be a selection bias. It could be that the defendants were representing themselves in the strongest cases and they were only turning to lawyers when the charges were more serious or the evidence stronger against them. Hard to tell, but at any rate, just in terms of sheer outcomes, self-represented defendants did a bit better than represented defendants in her study. One other thing she looked at is that there didn't seem to be an excessive number of motions questioning the competency to stand trial for these defendants who ended up representing themselves. So you don't see in the records any obvious indicators of lack of mental capacity to represent themselves. The second bit of evidence about this proposition comes from a recent study that Ralph Peoples and I put together trying to use 2006 data from North Carolina to create a rating system for defense lawyers in the state. And as a sidebar question in this research, we started noticing that if you list all the attorneys in the county according to the quality measures that we came up with, and I won't go into the details there, but if you list the attorneys in descending order of quality, one of the attorneys in every prosecutorial district is waived. That is, somebody who went forward without a lawyer. And those people, the waived defendants, were never at the very bottom of the list. There were always attorneys who did worse than waived. And these were repeat players, these defense attorneys, who were doing worse than waived. So again, maybe there's a selection bias going on, although we tried to control for seriousness of crime and seriousness of prior criminal record. So again, some possible evidence that maybe these folks do not have fools for clients and that they're doing okay for themselves. Now, while very few defendants actually go forward and represent themselves at trial, lots of clients waive counsel at the pretrial stage. Are these defendants mostly acting against their own self-interest? To get a sense of the number of defendants who waive counsel, you can take a look at the graphic here, showing waiver rates across a 5-year period from North Carolina, and you can see that that for these misdemeanors, the waiver rates range somewhere in the low to mid 30s. In Minnesota during the same period, for gross misdemeanors, the waiver rate was about 21%. Compare that to the waiver rate for felonies in North Carolina. The felony waiver rate was about 3%. But for these serious misdemeanors that could result in imprisonment, something like 30 to 35%, quite significant. So what's interesting is that unlike the trial context, where lots of actors try to block the exercise of Faretta rights, that is, they try to block waiver, we actually take several affirmative steps at the pretrial stage to encourage some of these waivers. Now, one of these practices is describing to defendants the financial risk involved in going forward with a lawyer. Now, it is true that the state provides a lawyer, appoints a lawyer for an indigent defendant, and ultimately the state will pay for that. But it's also true that the state can attempt recoupment. And if you really stress that fact to enough defendants, we might try to come collect this later on without really describing in detail how few defendants actually pay for counsel through these recoupment processes, then you might encourage a lot more waiver. Or some states use a different technique. Instead of describing recoupment after the fact, they charge an upfront, what are called sometimes application fees or filing fees. They're relatively small. They could be as low as $25 in some jurisdictions. They might be $50 or $100 in other places. They're charged automatically, but then in some states the judge has the power to override it and give the defendant an exception and not have to pay it. But The general thought is that every defendant pays this up front. Everybody's got to scramble and find 25 or 50 or $100 and pay that much at least for to get started with their lawyer. Talking to defendants about that might increase waiver rates. Now, if you're the chief public defender in a jurisdiction and you see that you've got a pretty substantial number of waivers, or if you see that the number of waivers is going up, how do you react to that news? Is that good news? Is that bad news? I think it's not entirely clear. On the one hand, perhaps you feel like the more people we can cover, the better. And you obviously know that, adding a lawyer to the mix normally is going to produce a better result for the defendant. At least as the chief public defender, you got to think that way, although some of our studies suggest maybe not. On the other hand, you may feel like, look, I've got a limited budget. I've only got, 6 people working for me here and just a, torrent of cases coming in the front door. And maybe it's a good thing that I don't have to cover all of them, because that kind of screening, even though it may not be entirely rational, it's, the selection of the defendants. And if they want to screen themselves out, that leaves me with fewer terrible dilemmas about how to spread out my very thin resources. So I think it may be that the leadership levels of public defender organizations are somewhat conflicted about waivers, and they may not especially want to drive waiver rates down. So you could sum it up this way. When you're talking about trial phase, Ferretta has no natural constituency. Everybody wants somehow to bring a lawyer into the picture, and normally there are ways for the judge to do that and get affirmed despite the autonomy doctrine of Ferretta. On the other hand, pretrial, waiver is everybody's friend. The prosecution doesn't mind that. That normally is leading to a guilty plea. The judge doesn't mind that. Again, it helps process cases. It's an indicator that I don't have to find a lawyer, get the lawyer up to speed, and then process the case. If it's not going to trial, if it's just going to plead out quickly, that is docket management. And then finally, even at least some elements of the defense community may find waivers a necessary evil. Maybe not the greatest thing, but given limited budgets, not an irrational way to make the best use of limited resources. So in this setting, everybody is the constituency for waiver pretrial. And there's one final practice going on in the background here that I want you to think about. Think back to the Spencer case. As Spencer is describing to the court why he wants to go forward himself, he says, well, that lawyer, he's just not listening to me. We're just not getting along. And this is a very common theme that you see in the cases describing these Ferretta disputes. The defendant initially maybe has a lawyer, and things break down along the way. Somehow things just, they don't see eye to eye. The defendant wants to do one thing. The defense lawyer thinks that's unworkable, not convenient, or just not smart. And so they part ways. They just have a disagreement about strategy. In that setting, the defendant I think the defendant's first choice would be new lawyer. But then it turns out you can't get a new lawyer. As our court in Nebraska says, in State v. Green, mentioned in your notes, beggars can't be choosy. It's not a very sophisticated statement of legal doctrine, but it actually sums up the court practice pretty well. Defendants who have appointed counsel can't come in and say, I want to get rid of this one and take that one. The court says, I appointed this one, and I'm not here to appoint your first choice of counsel. On the other hand, somebody who retains counsel can come in and say, yesterday I had somebody else, I fired him, I'm bringing in her. And the court says that's fine as long as you're not trying to do it on the eve of trial. As long as there's enough time before trial, I will allow withdrawal of the first counsel and appointment of the new counsel. So for retained attorneys, yeah, you got choices, but for beggars, as we say, beggars can't be choosy in the phrase of the Nebraska court. So I have here a picture of Oliver. Please, sir, may I have some more? May I choose my own lawyer? And the judge says, no, if I appointed the lawyer, you get one shot at a competent lawyer. Now, this is a big deal. This business about choice of counsel is maybe the most important force going on back behind the scenes of FRERETA. Because defendants are very often cantankerous clients. They are very often difficult to deal with. And you have lots of breakdowns in communication between defense lawyers and their clients. It's one of the major challenges, one of the major arts of being a really good defense lawyer, is maintaining this relationship of trust, building a relationship of trust under very difficult circumstances. And when that doesn't happen, really none of the constitutional doctrine supports, getting beyond that initial breakdown. And so rather than constitutional law, we turn here to good office management, to good interpersonal skills by individual attorneys. If you're running a PD's office, you probably don't want everyone able to fire the first lawyer and move on to the second lawyer. On the other hand, you want to do what you can to have happy clients and cooperative clients who are talking to their lawyers and giving them the materials they need to do the best job for the client. So this business about unhappiness between the lawyer and the client really driving a number of the motions for self-representation in FRERETA is an important management and interpersonal skills question for defense counsel, although it's not an especially important part of the operation of FRERETA as a constitutional doctrine. So that's it for my commentary on FRERETA.